This morning, at exactly 10:05, the U.S. Supreme Court issued a brief but weighty decision. They rejected a petition in a major case. There was no dissent from any of the 9 justices, and no separate opinion was written. The decision ended with 2 words: application rejected. The decision ended with 2 words: application rejected. Those 2 words effectively put an end to the months-long legal battle. What was even more striking was that this decision reportedly came exactly 72 hours after Melania Trump's lawyers allegedly offered federal prosecutors a special deal. In this offer, it is stated that the outlines of the evidence they are ready to provide in exchange for possible protection from prosecution are included. When 2 major legal developments occur just 3 days apart, the timing inevitably raises the question, are these connected? And it's not easy to dismiss this point as gossip because it is claimed that the accounts are based on public records such as court files, official agreement texts, and Supreme Court orders. So it's not about anonymous sources or secret leaks. According to the claim, it is about documents that everyone can access and review. That's why this claim is now more firmly on the agenda. Melania Trump renounced the privilege of being a spouse. What we call spousal privilege is a legal shield that normally prevents prosecutors from forcing one spouse to testify against the other. According to the claim being discussed here, Melania Trump is relinquishing this shield of her own accord. So it is not that she was forced, it is a voluntary renunciation. The evidence to be presented is also grouped into 3 main categories. Firstly, financial documents that are said to indicate knowledge of properties being inflated with unrealistic valuations. Secondly, correspondence and conversations back and forth between property values and loan documents. The third is personal testimony to support what accountants and bankers have already sworn to tell before the grand jury. And here's the critical part. Once the Supreme Court rejects the final appeal, there aren't many other doors left to halt this process. There is almost no new avenue for appeal, no move that would prolong the process, or no procedural maneuvering room. That's why it's said that the grand jury could hear his testimony in the next few days. On top of that, there's the pressure of timing. The approval process for his ex-wife as a cabinet nominee is at the beginning of March, which is about 6 weeks away. That's why that 72-hour window is important, because the order of what happens here doesn't seem random. Melania Trump's attorney submitted a filing to the special counsel's office. In legal terms, this is called a proffer agreement. At its simplest, think of a proffer as a kind of pre-interview/preliminary offer of information. The witness tells prosecutors what I know, what I'm prepared to say under oath, and which documents and evidence I can hand over. In return, prosecutors may consider granting the witness some form of immunity, meaning protection from being charged based on that statement. In federal cases, this mechanism is actually very common. The difference here isn't that it happened, it's who is alleged to have done it, and what was allegedly offered. Tuesday afternoon, 2 p.m., exactly 24 hours after the proffer was submitted, the defense legal team filed an emergency application with the Supreme Court. They asked the court for this: before the grand jury hears any of it, stop the process and block the statement from going forward. Their argument was this: a statement coming from a spouse like this violates marital privacy/marital protections as interpreted under the Fifth Amendment. Now, I have to say this: putting together an emergency Supreme Court filing within 24 hours is blazing fast. These kinds of applications are often prepared over weeks. The fact that this came together so quickly strengthens the impression that the defense saw this coming and had been preparing for it for some time. Wednesday morning, the Supreme Court formally received the application. It was assigned a case number and taken under review. But here's the critical detail: no stay was issued. A stay means that while the court is considering the matter, everything hits the brakes. If there's no stay, the legal process keeps moving while the court reviews the request. That silence can speak volumes. When the court grants an emergency stay, it often signals there may be something here worth taking seriously. When it allows the process to continue without a stay, many observers read that as there are serious doubts about how strong this objection really is. Thursday morning, 10:05 a.m., the Supreme Court delivered its final answer. One sentence: the application is denied. No justice dissented. Thomas didn't dissent. Alito didn't dissent. And neither did Trump appointees Gorsuch, Kavanaugh, or Barrett. In other words, the outcome was, as claimed, a unanimous denial. Sometimes the court will write even a brief explanation. That usually means this issue warrants some clarification. But when they close it out with a single sentence and no opinion, the message is sharper. In the court's eyes, the objection may not have been strong enough to even justify extending the debate. People who followed the High Court for years often say the same thing. These clean, unexplained denials don't happen all the time. And when they do, it's often because the court found the weakness of the argument so obvious that it didn't consider it necessary to spend pages explaining why. What's inside the proffer agreement? Because, according to what has been said, the evidence package presented is much more serious and systematic than it appears in the headlines. First category: financial documents. According to the allegation, he signed joint tax returns from 2014 to 2020. So, we are talking about joint tax returns for 6 years, where both spouses knowingly signed the joint returns, aware of the criminal consequences of falsely declaring the financial information. These types of declarations largely depend on how assets are valued, how much properties are worth, how much income they generate, and what deductions are applied. If the same properties are shown at a higher value when presented to banks for credit and at a lower value when reported to tax authorities, this scenario generally raises two issues: bank fraud and tax fraud allegations. And the signature on the joint declaration can practically pose separate legal risks for each signatory. In the content of the proffer, it is also mentioned that he was present at accountant meetings where asset values were discussed. It is even reported that he asked questions about how the properties were reported. It is claimed that these were also supported by emails that prosecutors allegedly already had. Second category: communications. In this title, it is said that there are messages between him and the defendant discussing property values before meetings with lenders. Additionally, it is alleged that there are questioning emails regarding the discrepancies between what was said to accountants and what was reported to tax authorities. Following this, it is also mentioned that there are recorded phone conversations discussing certain property values in connection with the loan applications. In federal cases, if the recordings were obtained in accordance with the relevant consent rules, such recordings can be considered as evidence. Moreover, if it is presented within a proffer, it is expected that the prosecutors have conducted a technical verification to determine whether this record is genuine and whether there has been any tampering. Third category: witness verification. This part is about reinforcing the statements of those who have already spoken before the grand jury. According to the allegation, there is a framework of testimony that could corroborate what the accountants already told the grand jury, support what the bankers said under oath, and bolster the appraiser's claims of pressure to inflate values. In federal cases, verification is a very critical thing. When a witness says, "These things were discussed in that meeting," it is strong. When a second witness confirms the same meeting with the same details, it becomes even stronger. When a third source presents documents, numbers, and tables pointing to that meeting, a layered pattern of evidence emerges, making it difficult for the defense to dismiss. Here is the biggest legal surprise hidden in this proffer. It waives the spousal privilege. Under normal circumstances, prosecutors cannot easily force one spouse to come and talk against the other. Because the law accepts that marriage rests on a certain foundation of trust and privacy, the judicial process should not go and shatter that foundation with testimony. But the critical point is this. This privilege can be relinquished at the person's own will. So it can be said, I am giving it up, instead of it was taken by force. In this proffer document, it is particularly emphasized that this privilege is explicitly left open for all the headings covered by the agreement, as described. This is a very big difference, because here it's not about the prosecutors forcing cooperation, it's about the person choosing to cooperate on their own. The collaboration of spouses has been seen before. For example, in organized crime cases, there are instances where the spouses of mafia figures have testified, sometimes to protect themselves and sometimes to break free from an already established chain of risk. A similar scenario can be observed in corporate fraud cases. In some business-related files, when spouses say, this legal risk also affects me, they may choose to cooperate with the prosecution. But what is being discussed here, if these allegations are true, is on a completely different scale, because the matter is not related to an ordinary businessman. It is connected to someone who once held the highest office in the country. And at this level, it is not normal, either legally or politically, for a spouse to come to the forefront of the case through financial records, correspondence, and direct testimony. The defendant's urgent application to the Supreme Court was based on three main legal claims, and according to reports, none of them were valid. The first claim was, a spouse testifying violates the marriage privacy protections under the Fifth Amendment. But the Supreme Court's long-standing line is clear. Spousal privilege can be voluntarily waived. Moreover, there is a precedent of approximately 150 years in this field. The most fundamental turning point is the 1980 Trammell v. United States decision. There, the court ruled that the spouse who controls the privilege is the witness spouse. So the decision means that the right to testify or not lies with the witness spouse, not the defendant. If the witness spouse says, I will speak, and waives the privilege, it is not easy for the defendant to prevent this. Within this framework, it has generally continued to be applied by federal courts to this day. Second claim. This proffer was obtained under pressure, threat, or coercion from the prosecution. Therefore, it is not considered voluntary. However, the filing reportedly includes a sworn statement bearing his own lawyer's signature, stating that the initial contact was made by us. So, according to the described scenario, the communication is initiated by the lawyer, cooperation is offered, and the terms are negotiated. It is emphasized that there is no summons, open threat, or coercion move involved. In short, the claim is that the proffer was entirely his choice. Third claim. If this is allowed, in the future, marital privacy will erode in all cases. A dangerous precedent will be set. But the problem facing the defense is this. There has been a precedent in this area for years. Spouses occasionally testify in federal cases when they choose to. And the Trammell decision largely framed this debate in 1980. There is a sense that what the defense is really seeking is, in practice, a special exception based on who the defendant is. However, the Supreme Court generally tries to maintain the same application line of the rule for everyone, instead of creating personalized exceptions. When the Supreme Court issues a one-sentence denial without any dissent, you are actually sending a very clear signal. These arguments were not just found to be weak, they were deemed not worth considering. To succeed in an urgent Supreme Court application, you need to demonstrate two things simultaneously: that an irreparable harm will occur and that you have a high likelihood of winning on the merits. According to reports, this application failed to demonstrate either. Because the recording of a statement is often the normal functioning of the system, winning on the merits would have required, in practice, reversing the trammel line, and it seems no judge was willing to do so. What will happen now? Since the appeal has been rejected, the grand jury may hear his testimony in the coming days. In this case, it is said that the grand jury meets on Tuesdays and Thursdays. It is often noted that this is standard practice in the Southern District of New York. If the prosecution is ready, as the proffer implies that this means prepared, there is talk of presenting the case to the grand jury within the next 7 days, even as early as next Tuesday. After the statement is completed, two strategic paths emerge before the prosecutor's office. First option, using this statement to further solidify the existing charges. The current indictment reportedly contains 34 counts related to falsifying business records and bank fraud. Second option, based on the new material presented, seek a superseding indictment to add new charges to the case. There is a particularly noteworthy detail here. A conversation from March 2020 mentioned in the proffer. According to the accounts, he claims to have been present during a phone call between the defendant and a banker, where property values were discussed before a loan application. If there is a scenario in that meeting where two people are knowingly making a false statement together, one says something, the other confirms it, both knowing it is not true, this can give rise to a conspiracy charge in terms of bank fraud. Conspiracy is a separate crime from the fraud itself. In its simplest explanation, it is based on two things: the agreement of two or more people to commit an illegal act, and at least one concrete step taken to carry it out. This case, in my opinion, leaves three important precedents that could influence the language and pace of federal investigations in the coming years. First precedent, the issue of spousal collaboration at the highest level. Yes, in the past, we have seen examples of spouses cooperating in organized crime cases, but the scale being discussed here is different. The spouse of someone who has held the highest office in the country coming to the center of the case with a narrative touching on financial records, correspondence, and direct federal charges. This is not a common picture at the presidential level. Second precedent, the Supreme Court's swift and clear resolution seems like a strong message against attempts to prolong cases with claims of privilege. 0 dissent, 0 separate opinions, and a one-sentence rejection. This kind of stance strengthens the line that federal processes will not be blocked for months with such tactics. Third precedent, accountability. It reminds us that it should operate regardless of how rich or powerful a person is. For years, some wealthy defendants have been able to try procedural moves to prolong the process with endless appeals, claims of privilege, and emergency motions. This case shows that when the courts move forward resolutely, the system can still work. The Supreme Court also did not write a lengthy justification because within the described framework, the law was already established. Spousal privilege can be waived, evidence is heard, and the fundamental principle remains unchanged. No one is above the law, neither with his wealth, nor with his claim of privilege, nor with endless objections. This process worked because the court took the established precedent and applied it directly.